Logan was removed from everything that he knew, everything. His friends at school, his dog, his father, his routine, his grandmother. 20 days. It will be 1 year exactly since this started. I've gotten to see my son 1 hour a week since July. He was illegally taken from me for 6 months over false accusations of a woman who was about to be exposed at work. 10 years ago, when Holly had an affair, she was caught in a 1.5 year long affair with a coworker, and have her doctor boyfriend in her work, and it's all good. I don't care. She can move on. She has my blessing.
Mom changed the minor child's school without dad's permission.
Maui versus Maui, taking time set for a parenting time show cause hearing as scheduled through the front of the court.
Good morning, Referee Hagan. This is Attorney Keith Kuhnman, P7456, on behalf of the plaintiff, Holly Maui.
Thank you. Ms. Maui?
Yes, Holly and Maui.
And Mr. Maui?
Yes, Lucas James Maui.
Thank you. Ms. Mullen?
Tracy Mullen on behalf of front of the court. We're here on complaints filed by Mr. Maui that Miss Maui is in violation of the default judgment of divorce, which was entered into August 11, 2023, in that she changed the minor child's school from Buckley Schools to Willow Hill without his permission or consent. He further alleges that she has failed to enroll the minor child in reunification counseling, which is also ordered as part of the judgment of divorce. 21-day notice was sent to parties on November 7th. Ms. Maui did file a response with her office, which was received on November 28th. She does acknowledge having changed the school due to a relocation on her end, which changed the school district for the minor child. Logan, I believe, is 11 years old, and on page 2 of the custody provision of the mediated agreement, final order regarding the party's minor child, contained within the judgment, it does say under number 4 that the minor child shall attend Buckley Schools unless the parties mutually agree otherwise. As far as the reunification provision under parenting time of the minor child on page 3, it indicates that the parties shall work in concert to enroll the defendant, counter plaintiff Lucas, and the minor child into reunification therapy at Kids Creek Family Counseling or Child and Family Services of Northwest Michigan if Kids Creek Family Counseling is unable to or unwilling to provide reunification therapy. It does, as part of her response, she indicates that she has reached out to in several attempts to find counseling for the minor child and Mr. Maui, but has not been successful in that. The minor child is in individual counseling. I believe Mr. Maui was also indicated that he's in individual counseling, but those counselors are not able and or possibly willing to do reunification therapy.
The judgment also provides them with joint legal custody, correct?
Yes, Your Honor.
Okay. So, Mr. Kuhnman, anything you'd like to say on behalf of your client?
Yes, Your Honor. I will address the parenting time concern first. I think Ms. Mullen did a good job of reciting the correct provision into the record. It does say that the parties will work in concert to set up the reunification therapy. My client has contacted at least 4 places to try and set it up. The 2 that are referenced in the JOD and also Wellspring Lutheran. She also contacted Fountain Hill down in Grand Rapids recently after the 21-day show cause was issued. They agreed to take the case, but they did it with a caveat of a $6,000 retainer, which is essentially not tenable for these parties. As Ms. Mullen stated, there's 2 really conditions that have to be met: the reunification therapy and counseling by Lucas to even begin the safe haven supervised parenting time. But the parties have moved forward because it seems that the reunification provision is just not workable. So he has begun the safe haven supervised parenting time, even though the reunification therapy and his therapy, I don't know if that's been met or not. So that's where we're at. It seems like the better solution here would be either a motion to modify the judgment based on the reunification therapy being non-workable, or the parties going back to mediation to find a solution, or thirdly, just moving forward with stage 2 of the custody and parenting time order that's always in place. But there's no active will by my client here to defy the court's orders with respect to that parenting time provision. With regard to the school change, I agree with Ms. Mullins' recitation of that issue as well. The only caveat that I would add is that the timing here, what happened is my client got out of the women's domestic violence shelter that she'd been in since January. She got out in April or May. The judgment of divorce entered in August, and my representation of her ended at that time. Shortly thereafter, it was in time to enroll the child into schools. She had relocated to the Willow Hill School District, as was stated, and was no longer in the Buckley area. She had 100% of the overnights, and she didn't understand that the obligation upon her with joint legal custody. She was just trying to do her best to get back on her feet and get the child enrolled. The child is doing well at Willow Hill. He's attending counseling. I believe my client attached letters from the teachers saying that he's doing well. And I don't really think that moving the child back to Buckley is in the best interest of the minor child, of the children, of the minor child, pardon me. The final thing I would note in my client's defense is that there is a PPO in effect here in this matter, which does make communication between the parties difficult, especially in light during that intermediate period after the entry of the judgment of divorce and my representation beginning. So with all that being stated, we would impress upon the court that there was no intent to violate the court's orders. If she did so unwillingly or unknowingly, and she is apologetic for that. But ultimately, the child is in a better situation. Thank you.
Thank you. Mr. Maui, anything you'd like to say or add?
We had enrolled Logan in Buckley schools for specific reasons, moral reasons, things like that. We just didn't want him in the Traverse City school district. When Miss Maui decided to leave the relationship on January 9th, the last time that I saw my son was January 8th. She removed him, Logan, everything's better for Logan. Logan was removed from everything that he knew, everything. His friends at school, his dog, his father, his routine, his grandmother. There's been nothing said here about the fact that Mrs. Maui completely removed Logan from my life, my mother's life, who has stage 4 cancer, who luckily she got to spend the last 2 weeks with Logan because she had COVID and she was at her house on oxygen. And I mean, I could go on for days, but the lawsuit, and when we do discovery, that's when all of this will come out. I sat here and I done everything that the court has asked me to do. I've not pursued Mrs. Maui. I have not even so much as asked one person if they know where she is, if they've talked to her, anything. I want nothing to do with Mrs. Maui. I have been trying to get out of this relationship for the past 3 years. And I can show records, and we will do that in discovery, on where I have quit my job. I left for 3 weeks last year. Mrs. Maui took this opportunity to build me up in order to chop me down. And before she left, I made a threat that I was going to call her boss and expose her for what she had been doing, because my mother had COVID at the house. She was not testing, and she was going into work at Thurlby Clinic, putting people in danger. And I said that because I was mad, because Mrs. Maui and me were fighting. She'd become angrier and angrier as the days went on. And now I have also heard through other people, my friends, that she went and did a slander campaign on. Mrs. Maui expected me to commit. And when I didn't, she went on a slander campaign. And during the slander campaign, she didn't figure that Luke would ever make it back out of that house. Well, through counseling, through just wanting my son in my life, I don't care about anything else. I want Logan. That is my son. I love him. I have never abused him. And my mind's just spun here. In 20 days, it will be 1 year exactly since this started. I've gotten to see my son 1 hour a week since July. He was illegally taken from me for 6 months over false accusations of a woman who was about to be exposed at work. And I shouldn't have threatened her. I shouldn't have, but I did. and Mrs. Maui decided to show her true colors, because this is not the first time that this has happened, sir. I believe that I spoke to you and Mrs. Your Honor Witten 10 years ago when Holly had an affair. She was caught in a 1.5 year long affair with a coworker, and her coworker put a PPO out on me.
All right,
And
so some of this, let's start to get,
Okay.
I'm gonna have to rein some of this in.
I'm sorry,
How does it
sir.
relate to the what's going on with reunification counseling? I mean, I don't want to totally cut you off, but 10 years
Right.
ago,
No,
I
I
didn't
know.
even
I
work
could,
here.
like I said, I could go on for hours. I'm sorry.
I was in a totally different county 10 years ago.
I know. Okay. But I have no communication with her, sir. And I did also write to you to try and get the PPO removed. I know that it was past the 2 weeks. I never tried to get the PPO removed because I never wanted to talk to Mrs. Maui again. I wanted to communicate through Wizard or whatever in order to co-raise our child, and she can go and do better and have her doctor boyfriend in her work, and it's all good. I don't care. She can move on. She has my blessing. I just want my son. I haven't done anything to him. I haven't.
So let me ask you this. Are you comfortable then proceeding to the next stage in the judgment?
100%.
Okay, so we're good with that. You're progressing in the steps, correct? I mean, part of the issue here, I can say, I have some concerns because I don't believe that
Sorry.
CFS even offers reunification therapy.
They
So
don't.
that's in the judgment. I mean, there's nothing we can do about that now. So I don't know if the two of you need to modify the judgment, or if you're willing to just move forward with the steps, let's just head there.
I-
For enforcement purposes, I don't know that either of you are doing anything wrong in terms of contempt for the reunification therapy. So for that aspect of this hearing, I'm not going to find Ms. Maui in contempt. And I would recommend that you continue to move forward. If you feel like you want that provision changed, you'll have to seek other relief. But in terms of contempt, I don't believe that she's in contempt there. It sounds like she's made efforts, that both of you are progressing. You're in counseling, sir. You're having the visits. So we're doing well there. The issue with schools, though, what are you wanting as your remedy there?
What is that? I want this person to quit acting like I died. I
For
am
this-
this boy's father.
Right,
And
right.
I want
Okay.
to say in his religion, his schooling, the people that he is around. My son came to a visitation the other day and told him that a person, he wouldn't tell me because his mother's instructed him to lie about who he's around. They stuck a 12-gauge shotgun in an 8-year-old's hand and let him shoot it while she sat there and videotaped it. Now I'm sitting here getting accused of threatening Mrs. Maui with guns, which I have never done. I got Mrs. Maui her CPL. I taught her how to shoot. I have taught my sons gun safety since they were old enough to recognize what a gun was. And I have sit here and I have been badgered. I have just been slandered to the point where it's almost no recovery. The only thing I have left is the lawsuit. The lawsuit.
Are you wanting your child to be returned to Buckley schools?
At this point, it doesn't even, I mean, what's it matter? Now I'm doing more damage, right?
Well, I don't
This
know.
kid's already
This is
been
you
through enough.
filed the complaint. I'm looking for what you want. She's in contempt of the order. That is a
Yes.
finding I'm making. So on the school issue, I don't buy that she didn't understand the joint legal. And then not only that, but it's spelled out in paragraph 4. So you all specifically stated you wanted it to be sometimes people say, well, I didn't know what joint legal custody is, I guess, but I don't believe that's the case here. And it's you can't deny that you all
It's clear.
agreed that Buckley Schools was going to be the school. My question is, are you I'll get to a consequence in a second. She's in contempt for sure on that issue. But what are you wanting as your remedy for the school?
I want to be able to talk to the people that are educating my child. I don't think it's fair in any way.
Do you want him removed? Do you want him placed back in Buckley Schools is what I'm asking.
No, I don't want him placed back in Buckley schools.
All right. So, ma'am, I do find that you understood the order. I believe that you willfully violated the order. It's really hard for me to imagine that you didn't know when you specifically agreed that Buckley Schools was going to be the school, and then you moved the child without seeking any type of consent with Mr. Maui. I mean, you could have had a hearing We could have gone over this. It's too bad the child's doing, or well, I shouldn't say it's too bad. What I was gonna say, it's too bad that you violated the order. It's great that the child's doing well. I'm even happier that Mr. Maui is consenting to the child remaining where he is. That's what I would prefer, or at least, we have a hearing on whether that school is appropriate. But right now, I trust Mr. Poonman that your child's doing well. So I'm gonna leave the school as is. But any change from there, just remember you have joint legal custody. You're not able to do that. In terms of any type of consequence, I'm going to issue a $300 fine for violating the order. You'll have 6 months to pay that. If there's child support ordered, I'm comfortable if it's just in as a credit, so that she doesn't have to pay cash. But just remember, you have joint legal custody, and that's these types of decisions. If the two of you can't agree, you have to come to court first. I believe that you probably did that in the minor's best interest, but you have to, because the two of you don't agree, or I don't even know. There's not really any record of you even reaching out to ask Mr. Maui if that's okay.
I had a
He's
reason.
okay with it today, but you obviously knew that when you wanted Buckley to be put in your judgment, that was the school you wanted. So to change it was inappropriate and contemptuous. So you have the right to file an objection if you believe that the court made any errors, or if you have any issues with the court's ruling today, and then your objection would be heard by a judge. So thank you all. We'll stand adjourned.
Thank you.
This father says his son was ripped from his entire world, his school, his home, even his grandmother battling stage 4 cancer. The mother admits she changed schools without permission. Now the court must decide, was this survival or contempt? And more importantly, what's best for 11-year-old Logan? Here's where emotion floods the courtroom. Mr. Maui isn't arguing policy, he's grieving disruption. He paints a picture of total removal: friends, dog, father, grandmother with terminal cancer. Legally, however, emotional devastation doesn't automatically equal a custody violation. The court must separate two things: whether a parent acted within their authority, and whether the child's best interests were harmed. His limited 1-hour weekly parenting time and allegations of false accusations add gravity, but today's hearing is narrowly focused: school change and reunification therapy. Notice how the referee begins steering him back to relevance. In family court, relevance wins over rage. The $300 fine is symbolic but significant. It reinforces a powerful message: joint legal custody means joint decision-making, period. However, the court also acknowledges Mr. Maui's current consent to leave Logan in the new school. That flexibility likely influenced the outcome. If he had demanded immediate return to Buckley, we might have seen a different trajectory, possibly a best interest evidentiary hearing. Instead, the referee balances enforcement with stability. Accountability without uprooting the child. That's classic family court tension, enforcing orders while minimizing collateral damage to the minor. Whose position do you think ultimately carried more weight here, the father's principle, or the mother's relocation reality? In the end, the court draws a clear line. The mother is not in contempt regarding reunification therapy because efforts were made and the provision may be impractical. But she is in contempt for changing Logan's school without consent, resulting in a $300 fine. The child remains at Willow Hill, largely because he's reportedly thriving and the father no longer seeks reversal. This case teaches 3 major lessons. Keycap 1: joint legal custody requires shared major decisions, especially schooling. Keycap 2: if an order becomes unworkable, you modify it, you don't ignore it. Keycap 3: courts balance enforcement with the child's stability above all else. So what do you think? Did the referee strike the right balance between accountability and stability? Should the school change have triggered a stronger consequence? If you found this case as shocking as we did, hit like, comment your thoughts, and subscribe for more intense courtroom breakdowns.